Biggest gun ban going away. That is the claim. But which one? There are roughly a dozen assault weapons bans currently on the books across different states, and they are not remotely equal, not in age, not in population covered, not in how thoroughly they have already been tested in court, not in how legally exposed each one currently sits. Before we can even ask whether the Supreme Court is about to take one down, we need to answer a more basic question nobody actually asks. Which of these bans is genuinely the biggest? By which specific measure? And what does that actually mean for the case now sitting in front of the court? Let's rank them, honestly, against the real numbers, not against whichever state happens to generate the most headlines this particular week. Quick thing before we get into it. I check comparative claims like biggest against actual population figures, actual enactment dates, and actual litigation records, not against whichever state happens to be in the news that week, or whichever example makes for the most dramatic opening line. If that is useful, subscribe and turn on the bell. 2 seconds, and let's get into the actual ranking. First, the case itself, briefly, since it is the reason any of these individual state bans is suddenly getting fresh attention after years of relative quiet at the Supreme Court level specifically. On June 30th, 2026, the Supreme Court granted certiorari in two consolidated cases, Viramontes versus Cook County out of Illinois and Grant versus Higgins out of Connecticut, agreeing for the first time to decide directly whether the Second and 14th Amendments protect the right to possess AR-15 platform rifles and similar semi-automatic firearms, a question the court had specifically avoided answering directly for the 18 years since it first recognized an individual right to keep and bear arms. Oral argument is expected this fall, and a decision is expected by June of 2027. This is not a ruling yet. Nothing has changed in any state's current law, and every ban on the list I am about to walk through remains fully enforceable today regardless of this cert grant. What this case does is set up a single, nationwide answer that will likely determine the fate of every one of these bans at once, which is exactly why understanding which one is actually biggest, by whatever measure matters to you, is worth doing now rather than waiting for the ruling itself to sort out the confusion after the fact. Let me clear up one specific misconception before we get into the actual ranking, because it shapes how you should think about every measure that follows. Some coverage of this case treats it as though the Supreme Court is specifically striking down Illinois and Connecticut's laws, full stop, with every other state's ban simply an afterthought. That framing understates what is actually at stake. The court granted certiorari on a category-level question, whether the underlying class of firearm is constitutionally protected, not a narrower question limited to these two states' specific statutory language, which means the eventual ruling's reasoning will control how every other state's comparable law gets evaluated, even though only Illinois and Connecticut's specific statutes are technically, formally, before the court in this particular case. Let's rank by population covered first, since this is probably the measure most people actually mean when they say biggest, the number of actual people currently living under some version of this restriction right now today regardless of any pending litigation. California is the clear leader here, by a wide margin, since it is by far the most populous state with any form of assault weapons restriction, meaning more Americans currently live under some version of this kind of ban in California alone than in every other restricting state combined, roughly speaking, given California's population of nearly 40 million against the combined population of every other restricting state. California's law dates back to 1989, following a school shooting in Stockton, making it also one of the oldest bans on this entire list, originally a narrower, named model list that has been amended and expanded multiple times over the decades since, most notably following the expiration of the federal assault weapons ban in 2004, when California moved to fill the regulatory gap the federal government's own sunset provision had just created. New York ranks second by population, its current version rooted in the 2013 SAFE Act, the Secure Ammunition and Firearms Enforcement Act, passed rapidly in the aftermath of the Sandy Hook shooting the same year Connecticut passed its own ban, both states moving within months of that specific tragedy to enact comparable restrictions. Illinois ranks third, with Cook County's 1993 ordinance, the actual subject of the Viramontes case, later expanded into a full statewide ban that Illinois' legislature modeled directly on the county-level ordinance that had already been operating for years within Chicago and its surrounding suburbs. New Jersey and Massachusetts follow, both with meaningful populations and long-standing restrictions of their own. New Jersey's dating back to the early 1990s in a similar wave of state-level responses to rising concern about this category of firearm during that era. By pure population covered, in other words, California is unambiguously the biggest ban on this list, even though it is not the one formally named in the case the Supreme Court just agreed to hear, a genuine mismatch between the state most people would probably guess and the state the court actually chose. Now, let's rank by age, because oldest and biggest are not the same question, and the oldest laws carry a different kind of significance, having survived the longest without being struck down, weathering decades of changing legal standards and repeated litigation attempts. California's 1989 law is the oldest comprehensive assault weapons restriction still standing anywhere in the country, predating even the federal assault weapons ban that existed nationally from 1994 to 2004 before Congress allowed it to expire without renewal, meaning California's own state law simply continued operating uninterrupted through the entire period when a parallel federal restriction existed alongside it, and then kept operating for the more than 2 decades since the federal version disappeared entirely. Cook County's 1993 ordinance in Illinois is the second oldest, and it specifically became the template Illinois' own statewide legislature borrowed from when it passed its broader version years later, meaning Cook County's law has an outsized legal and legislative influence relative to its own relatively small geographic footprint within just one county, essentially functioning as a policy prototype that outlived its original, narrower jurisdiction by becoming the model for a much larger statewide law. Both of these predate the modern era of Second Amendment litigation entirely, having been enacted well before the Supreme Court's 2008 ruling in Heller first recognized an individual right to keep and bear arms, which means both have had to be independently defended and rejustified under legal standards that simply did not exist when they were first written, surviving not just changing public opinion but multiple entirely new constitutional frameworks imposed on them well after their original passage. Now let's rank by legal significance, meaning how thoroughly each specific ban has already been tested in court, since a ban that has survived multiple rounds of serious litigation carries a different kind of weight than one that has never faced a serious challenge, and this measure of biggest is arguably the most important one for actually predicting what happens next. Maryland's ban holds a genuinely unique position here. It was upheld by the Fourth Circuit Court of Appeals in a case called Bianchi v. Brown, a ruling that has since become the controlling precedent blocking similar challenges throughout that entire circuit, which covers Maryland, Virginia, West Virginia, North Carolina, and South Carolina, including, notably, the federal lawsuit challenging Virginia's brand new 2026 ban, since Virginia sits within the same Fourth Circuit as Maryland and is therefore directly bound by that circuit's own prior ruling until something supersedes it. That single ruling has outsized influence extending well beyond Maryland's own borders specifically because of its position as binding circuit precedent, meaning any plaintiff challenging a similar law anywhere within that 5-state circuit currently has to overcome Bianchi directly before even getting to the merits of their own specific case. Illinois and Connecticut, the 2 states actually named in Viramontes and Grant, both had their bans upheld by their own respective circuits, the 7th and the 2nd, before reaching the Supreme Court, meaning both cases arrive with a fully developed lower court record, specifically testing the exact common use and historical tradition arguments the Supreme Court will now have to evaluate directly, rather than a thin or underdeveloped factual record that might leave important questions unanswered even after a ruling. By this measure, Illinois and Connecticut are, in a real sense, the biggest bans right now, not because of their size or age, but because they are the 2 the Supreme Court specifically chose as the cleanest vehicles to resolve this question nationally, out of every ban that could theoretically have been selected from among the roughly dozen candidates available. There is one more ranking worth adding to this list, because it captures a genuinely different, broader category than the rifle bans alone. If you rank by how many states restrict some piece of this overall regulatory picture, not just full rifle bans specifically, magazine capacity restrictions reach considerably further, covering roughly 13 states, a larger group than the roughly dozen states with comprehensive rifle bans. Since several states restrict magazine capacity without having anything resembling a full assault weapons ban at all. Colorado is a useful example of this exact distinction, since the Department of Justice's own Second Amendment section has separately sued Colorado specifically over its magazine capacity law, distinct from any rifle ban, applying the same basic constitutional theory to a different and in some ways broader category of restricted item. If the Supreme Court's eventual Viramontes ruling reasons broadly enough to treat magazines themselves as protected arms under the same common use logic being applied to the rifle question, the practical reach of that ruling would extend even further than the dozen states with rifle bans specifically, touching every one of those 13 magazine-restricting states at once. A genuinely bigger number by this particular measure than any single ranking of rifle bans alone could capture. Let's talk about why the court chose Illinois and Connecticut specifically, rather than California, the biggest by population, or Maryland, the one with the most directly relevant circuit precedent already established. This is worth understanding because it tells you something real about how the court selects cases generally, not just in this instance, and because the selection process itself is a genuine strategic choice, not a random accident of which case happened to reach the docket first. Cook County's ordinance and Connecticut's statute had each been fully litigated to a final judgment at the circuit level, giving the court a genuinely complete, well-developed factual and legal record to work with, exactly the kind of clean vehicle the court tends to prefer when it knows it is about to settle a major, nationally binding constitutional question rather than a narrow, fact-specific dispute that might leave important pieces of the underlying question unresolved. California's law, despite covering the largest population, was not the specific vehicle chosen, in part because litigation challenging it specifically had not reached the same fully resolved procedural posture at the time the court was selecting a case, meaning a genuinely bigger, more populous state's law simply was not as procedurally ready to serve as the vehicle for this exact question, regardless of how many people it actually affects. Maryland's law, despite its Fourth Circuit precedent already existing, had itself been passed over the year before, when the court declined to hear a direct challenge to it in 2025, with Justice Kavanaugh specifically signaling the court would wait for a cleaner vehicle rather than force the question through that particular case immediately, a deliberate choice to wait for exactly the kind of dual-circuit consolidated case Viramontes and Grant together eventually provided. Now here is where all of this actually matters practically, because the answer to which ban is biggest genuinely changes what a Viramontes ruling would mean for you depending on where you live. And it is worth walking through each scenario concretely, rather than treating this as a purely abstract ranking exercise. If you live in California or New York, the states covering the largest populations, a ruling striking down assault weapons bans nationally would affect more people directly than in any other single state. Even though neither state's law is the one formally before the court right now, meaning residents there would likely need to wait for a follow-up case specifically challenging their own state's statute, even after a favorable Viramontes ruling establishes the controlling legal principle nationally, unless their own state's own attorney general or legislature simply chooses to concede the point and repeal or narrow the law voluntarily, rather than forcing a separate round of litigation to establish what the Supreme Court's own reasoning already makes fairly predictable. If you live in Illinois or Connecticut, your state's specific law is the actual, direct subject of the pending case, meaning whatever the court decides will apply to your state's statute immediately and directly, without requiring a separate follow-up case the way Maryland, California, New York, New Jersey, Massachusetts, Delaware, Hawaii, Washington State, Rhode Island, Maine, and Virginia would each technically still need, even though the underlying reasoning would apply to all of them eventually. If you live in Maryland specifically, your state's law is currently protected by binding Fourth Circuit precedent that a favorable Viramontes ruling would directly override, since a Supreme Court ruling supersedes any individual circuit's own prior conclusion, meaning Maryland's own legal position could shift from being one of the most secure on this entire list to one of the most exposed, almost overnight, depending entirely on how the Supreme Court's own ruling comes out. If you live in Virginia specifically, your state's brand new ban is already the most legally unstable in the entire group, and a Viramontes ruling in either direction would likely determine how that already uncertain situation finally resolves, layering national precedent on top of litigation that is already actively moving through Virginia's own courts on a separate, faster timeline. Let's also rank these bans by how legally vulnerable each one currently appears heading into oral argument, since this is a genuinely different question than age, population, or which court already ruled on it. And it may actually be the most practically useful ranking of all for anyone trying to gauge which state's law is most likely to change soonest. Regardless of what the Supreme Court eventually decides about the underlying constitutional question, Virginia's brand new 2026 ban is arguably the most legally unstable of the entire group right now, already blocked by court injunctions in multiple jurisdictions following a wave of lawsuits filed within days of its signing, 4 separate state cases plus a federal lawsuit plus an unusual direct lawsuit from the Department of Justice itself, filed the very day the law technically took effect. Colorado's ban, taking effect August 1st, has not yet faced the same volume of litigation simply because it has not yet been in effect long enough to generate it, though given the pattern Virginia's law has already established, similar challenges seem likely to follow quickly once Colorado's own ban actually takes effect and creates real, enforceable consequences for someone to challenge. The older, more established bans in California, New York, Illinois, and Connecticut have, by contrast, already survived years of litigation and multiple rounds of appellate review, meaning they enter this moment from a position of demonstrated legal resilience, at least at the state and circuit level, even as they now face the single largest test any of them has ever encountered, a direct, nationwide Supreme Court ruling on the core constitutional question underlying every one of them at once, a test that none of their prior litigation history actually guarantees they will survive, regardless of how many previous rounds they have already won. So here is the actual honest answer to the question in the title, broken down by the specific measure that actually matters for your own situation, since a single word like biggest genuinely means different things depending on what you are actually trying to figure out. If biggest means most people affected, it is California, by a wide margin, home to more residents living under some version of this restriction than any other state combined with several others. If biggest means oldest, longest standing, it is also California, with Illinois' Cook County Ordinance close behind, both predating the modern Second Amendment litigation era entirely. If biggest means most legally significant right now, in this specific moment, it is Illinois and Connecticut, the 2 states the Supreme Court actually chose to resolve this question, out of every other candidate available to it. If biggest means most legally secure heading into this fight, it is arguably Maryland, protected by its own circuit's binding precedent, at least until Viramontes potentially overrides it and strips that protection away in a single ruling. And if biggest means most legally vulnerable right now, it is Virginia, the newest ban, already tied up in injunctions before it ever had a real chance to be enforced even once. Step back and look at what this ranking exercise actually demonstrates, beyond just answering a title's literal question. A dozen different state bans built at different times for different reasons, tested in different courts to different degrees, are all about to be evaluated against the exact same underlying constitutional question at the exact same time, through a single Supreme Court ruling that will not ask which state's law is biggest by any of these measures, only whether the underlying category of firearm these bans all restrict is constitutionally protected. That is the actual unifying stake here, bigger than any individual state's specific statute, regardless of which measure you use to rank them against each other. And it is worth remembering that whichever specific state's law technically sits before the court, the eventual ruling's reasoning is what actually matters for every other state on this entire list, not the specific facts of Cook County or Connecticut in isolation. There is a broader lesson worth taking from this exercise too, one that extends well beyond gun law, specifically, and applies to how you read almost any legal news story involving multiple affected parties. Whenever a single Supreme Court case is described as resolving an issue affecting multiple states or multiple parties, it is worth asking exactly which specific party's facts are actually before the court, and how that specific case relates to the broader category of similar situations it is expected to control, rather than assuming the named party in the case's title is automatically the most significant example of whatever broader category the ruling addresses. The state, or the person, or the specific set of facts formally named in a Supreme Court case's title is not always the biggest, the oldest, the most affected, or the most legally exposed example of the underlying category the ruling will eventually govern, and understanding that gap between the named party and the full scope of who the ruling actually affects is a genuinely useful habit for reading legal news accurately in any area, not just this one, and not just for cases involving Supreme Court certiorari specifically. If this helped you actually understand which specific ban matters most for your own situation, instead of a vague, undifferentiated claim about the biggest gun ban going away, hit like, so it reaches other people trying to understand how their own state's law fits into this bigger picture rather than treating every state as interchangeable. And subscribe if you have not, because I will be covering oral argument this fall and the ruling itself next year, breaking down exactly how it applies to each of these individual state laws once we actually know the answer, state by state, rather than treating this as a single, undifferentiated national story that resolves identically and simultaneously everywhere. Tell me in the comments which state's ban you want ranked and explained in more detail next, because that tells me exactly where to go deeper as this story continues to develop over the coming months. Whether that is a deeper dive into California's own specific litigation history, or a closer look at how Virginia's currently unstable ban is likely to resolve before the Supreme Court ever weighs in.